This year's Ella Conference is appreciative of all of our sponsors. Our presenting sponsor, Gallagher. Our gold sponsors, the Arkansas SHRM chapters of NOARC and CARA, Windstream, Cross Gunner Witherspoon and Gauchus, and Wright Lindsay Jennings. Our silver sponsors, SFLIC, Consolidated Admin Services, Friday Eldridge and Clark, and the West Central Arkansas SHRM chapter. Our bronze sponsors, First Staff and the Human Resources team. Now, let's hear a special welcome from Mike Moore with Friday Eldridge and Clark.
Hey, y'all, welcome to the 2021 Ella Conference. I'm Mike Moore with Friday Eldridge and Clark and want to welcome y'all here. Even though we can't all be together, I think we'll have a great couple of days. COVID has changed all our lives, and it sure has changed ours at the Friday firm. I said 3 months ago I was happy because I wasn't having to be a COVID lawyer anymore, and the Delta variant showed up, and here I am. I'm a COVID lawyer today. We have a wonderful, talented, diverse group of employment lawyers, and we had to learn how to diversify our practices during COVID. When the rest of our firm went home, we stayed. We all stayed on our little hallway, and we took a subspecialty each and went everywhere from FICR compliance to PPP loans to shared work programs under the unemployment laws. And I think we delivered some real value to our clients. We plan to do that in the future. There's a lot more COVID that we're going to have to navigate the next couple of years, especially with the vaccination mandates and the mask mandates. We've been involved judicially and legislatively in trying to do the best for our clients, and we plan to keep doing that. Thank you and welcome.
Hello everyone, my name is Lanny Richmond. I'm Senior Legal Counsel with the Arkansas Municipal League. For those of you who don't know what the Arkansas Municipal League does, we represent the 500 cities and towns in Arkansas, and as you might imagine, that is a lot of employees to handle when you've got that many clients. So today I'm going to be talking about the Equality Act, which is currently pending before Congress. I think it's in the Senate. It would be a pretty massive and probably the largest change to civil rights laws since probably 1974. There's a lot of provisions to it, a lot of history, and I think it's something that even if it doesn't pass, it's very important just to get a grasp on what people are thinking and where it may be headed. And with that, I'll jump right in for everybody. So why are we here? The Equality Act, of course, but also I think it's very important to have a good grasp of the history and what's going on with this legislation. For my whole life, for example, I've lived under the Americans with Disability Act, the ADA, and that's a fact of life. It's something I've not ever given two thoughts about. But at various points I've had to go back and really learn about it, the history and how it got there. And if you go back and look at some of the reasons and what people had to do to push to get that to happen, it's stark. It is sort of a shocking series of events. So throughout this presentation, I may be jumping back and forth a little bit between the proposed law, the Equality Act, the current laws that we have in place, all the EEOC and other ones that are subject to amendment, and then some history, because I think having the context is very important for these sorts of things. But I always like to start with the findings of Congress, why Congress says we're here. So what you'll see here is just copied from the Equality Act. You'll see the little paragraph number, and that's the number associated with the Equality Act. And if you'll forgive me for reading to you for just a second, just bear with me. So here's why Congress says we need this. Lesbian, gay, bisexual, transgender, and queer, LGBTQ, people commonly experience discrimination in securing access to public accommodations, including restaurants, senior centers, stores, places of or establishments that provide entertainment, healthcare facilities, shelters, government offices, youth service providers, including adoption and foster providers, and transportation. Forms of discrimination include the exclusion, denial of entry, unequal or unfair treatment, harassment, and violence. Discrimination prevents these people from integrating fully into society and disrupts the free flow of commerce. So I'd like to just think about that for a second, what Congress is saying is happening. We have several groups of people who are being excluded from pretty basic things that I've never really had to give two thoughts about. I don't worry when I go to a restaurant that I'll be turned away or subjected to ridicule, harassment, or just, negative comments. Maybe if, I don't tip enough, but not certainly for trying to walk in the door. And this is what people face every day, and it's something that they're trying to battle with this. So I'll touch on a few more findings and just kind of go through them. I won't read them all to you. I know that's the most boring thing a presenter can ever do. But the next finding, paragraph 11, something else to keep in mind is how important just we are, local government actors, state actors, federal actors, how difficult these things are for housing. Have you ever had to stop and think for a second, when I turn in an application, what are people going to think if I have my spouse listed? Usually not. I certainly never did. I always thought, hey, when I was married, they'll probably like seeing this application with two names on it. But it may be different when the two names are of the same gender or same sex. They may go, ooh, these people are applying. And that's another large factor in the Equality Act, and why Congress is doing this is to stop just these little things that add up to huge differences for people. And then I'll point out, and this will be the last finding I quote to you, it's the act makes explicit the existing federal statutes prohibiting sex discrimination in employment, which we already know, including access to benefits, healthcare, housing, education, credit, something we may not have thought of, jury service, also prohibits sexual orientation and gender identity discrimination. And I won't bore you with continuously reading these to you, but thinking about credit for a second, I hope everyone will allow me one personal anecdote. I can see how that would be difficult. Again, the applications with similar names that may be shocking to some people. But just all you people out there in Arkansas, and I'll say if anyone somehow from another state watches this, especially a southern state, again, my name is Lanny Richmond II, and nothing gives credit agencies and banks more trouble than naming your child the exact same thing as you. I have to continuously describe to them, no, I'm Lanny Richmond, born in 1990, not the felon born in 1956. So, just kind of think about that when you're choosing your names for your kids. So there's some positives, easy to remember, some negatives, literally every official application. So I hope y'all bear with me on that, but I'll press on. And finally, here's the express purpose of the Equality Act. And after this, again, I swear I'm going to quit reading to you. It's the purpose of the act to expand as well as clarify and create greater consistency in the protection and remedies against discrimination on the basis of all covered characteristics, and to provide guidance and notice to individuals, organizations, corporations, and agencies regarding their obligations under the law. And you're really going to see this. So I think, as the next slide will say, we all know about Title VII. You can't discriminate in employment. And after the Supreme Court case in 2020, Bostock, we know that the discrimination on the basis of sex includes sexual orientation and gender identity. But it's Title VII, and something I rarely thought about before I got pretty deep into the practice of law is that 7 means there's a whole lot of other titles out there. And primarily what the Equality Act does is amend several of these titles. And these titles came from the Civil Rights Act of 1964. So there was 11 total titles in this. Some of the big ones being amended and just ones that impact everyday life, even if you didn't know about it. Title II, the right to freedom from discrimination in public accommodations. Title VI, federally assisted programs are free from discrimination. You may have seen that one if you've ever gotten on a public transit, either a trolley, a bus, railroad, what have you. Usually they've got Title VI postings because they get a lot of direct funding if you've wondered how those things stay in business, like the trolley in Little Rock and North Little Rock. And as we all know, Title VII, employment. So again, all these are getting amended, and several other things by the Equality Act. These are sort of the cornerstones, the big ones, the big fish, if you will. And if you'll allow me now, I'm going to back up. I'm going to back up to some of the other things. And we can take a quick look at all the titles. So just so you know, put yourself in the feet of someone in 1964. I think at this point we haven't landed a man on the moon yet. and we don't have very many anti-discrimination laws in the world. Maybe through the Rehabilitation Act, I don't even know if that one was there yet. But here's what this did in 1964. Landmark legislation, biggest of most people's lives. Secured voting rights, secured freedom in public accommodations, desegregated public facilities, desegregated public education, created the Commission on Civil Rights. Title VI, non-discrimination wherever federal money is going. Title VII, freedom from discrimination in employment. And then added some other sort of administrative and mechanical provisions with 8, 9, and 10. Quick note, this Title IX is not the Title IX you think of in education. That came later. That was part of some education amendments in the 1970s. So when you think about Title IX, it's not quite these titles. But as I think we all know, education receives a lot of federal funding, and the Equality Amendment's pretty explicit on if you get federal funding like Title VI here, you're going to be playing by the new non-discrimination rules. So just some history. So the Civil Rights Act that we have today was passed in 1964. There were several repeated attempts at this to get this passed in 1957, 1960. Everyone knew it was a problem. And it was such a unique situation because each party during the run-up to that election ran on a platform of, civil rights. We're the party of civil rights. It's going to be us. So it was sort of everyone was kind of on board, but we still hadn't been able to do anything. And it was getting kind of out of hand. You know, the gridlock, just no one could get anything done. And President John F. Kennedy had to send 2 letters to Congress. And just the highlight of the second letter he sent, just trying to push them, just get something done, guys, is describing these civil rights issues as a rising tide of discontent that threatens public safety. And the events in Birmingham, so we know what happened in Birmingham, Alabama, and elsewhere. So, you know, Congress starts taking this seriously. They are looking at 172 bills on EEOC laws. This is what was before them in the 1960s. And the bill that would become Title VII originally just didn't even include anti-discrimination for sex, for women. It wasn't even part of it at this time, and they just kept going back and forth over these huge debates. But this man, Howard Smith, strongly opposed the legislation. And as a bit of a joke, at this point, you know, this was just freedom from discrimination on race, national origin, those sorts of things, color. No mention of sex. And he added it in there. He said, oh no, you know, this is what I want. And my understanding of the history is that he wanted to defeat the bill by providing this extra protection. He thought, well, hey, people surely won't want to protect women's rights. So he added an amendment saying, no discrimination based off of sex. And he had this fake letter where he read about it, and when he entered it in, you know, he was greeted by laughter. So in the letter he said, I got this lady, one of my constituents, she has a real grievance. And in this sort of fake letter he's reading to mock, you know, equal rights for women, you know, complained that, women outnumber men, and Congress and the president have made the situation worse by engaging in wars that further the imbalance. And the imbalance prevents women from attaining their rights to happiness. And this was a joke letter a man was reading as he was amending Title VII to include sex protections. Now then, another good one, just again, I hope y'all bear with me through this history lesson, was someone in support of it, his sort of retort to this man mockingly adding protections for sex. And he said, I can say as a result of 49 years of experience, and I celebrated my 50th wedding anniversary next year, that women indeed are not a minority in my house. I usually have the last 2 words, and those 2 words are, yes, dear. And this was the man who was also making a joke, but was for this legislation. So, and again, I'll just point out, the man thought he was going to defeat Title VII by adding in protections, but it passed, you know, to his chagrin that he provided everything we're talking about here today, at least the groundwork. And just real basic, just to get our minds in the right place and keep us geared toward the law. Title VII and most everything has two main provisions when it comes to protecting equal rights. There's an anti-discrimination provision, which says, no one shall ever be denied employment or privileges, compensation, terms of employment because of an individual's race, color, religion, sex, or national origin. And we'll never segregate employees that way. And then again, every law has that. Fair Housing Act, Fair Credit Opportunity Act. It's you can't discriminate. And then they almost always have an anti-retaliatory provision, which is if someone tries to use this law, if someone tries to oppose this sort of discrimination, that's also illegal. And you'll see this throughout all of them. I'm just placing them in here to get everyone's minds in the right place as we continue on through this presentation. So, and just to keep in mind how much of a struggle this has always been, the Pregnancy Discrimination Act came around in 1978. It was much later. So between 1964 and 1978, people were discriminating against pregnant women, and the court said, yep, that seems fine to us. They're pregnant. They're not doing it because of anyone's gender. It took 14 years for them to realize that was a mistake and fix it. Now then, there's going to be some provisions about pregnancy and pregnant women, regardless of how you identify, in the Equality Act. And you'll see that it's kind of making things a bit better and making sure that they're treated similarly in the other titles, not just Title VII, which the Pregnancy Discrimination Act amended, public accommodations, and so on. So that's sort of the backdrop of just the law, just equal rights in this nation as we see them today. So I think a big sort of turning point in all of this was the Supreme Court last year in the decision Bostock v. Clayton County, Georgia, where ultimately a couple of the conservative justices joined with several of what we know as the liberal justices and held that Title VII, when it says you can't discriminate because of sex, that includes gender identity and sexual orientation, and that's just not something that we can do anymore. And Justice Kennedy, writing for the majority, Justice Gorsuch, my apologies, writing for the majority, had some pretty good statements. So I'll read at you one more time, but I think it's very important just to keep these things going. So the statute, Title VII's, message for our cases is equally simple and monumentous. An individual's homosexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual on the basis of sex. So to the majority, and I think to people leading up to this had been argued for a long time. It couldn't be more clear. Because of sex meant treating people differently because their gender didn't conform to their birth sex or their preference in partners was the same thing as sex discrimination. These are two sort of logical conclusions that vastly spread equality and just inclusiveness throughout the law. And here's the arguments, how they were always framed leading up to this. And it was, well, let's say I want to fire this person for being homosexual. Their argument under Title VII was, you're only doing that because I'm a man. If I was a woman, you wouldn't have two cares in the world that I was dating this guy. And it seems kind of like clearly the winning argument, because how else, it's true, it's factually true, that is because of sex. So I'll also take a moment just to digress and say, let's not get too, sort of binary about our Supreme Court. There's 9 members on there, varying levels of what we think about them, but they have their own jurisprudence. It's sometimes difficult to predict where they'll go. And the Chief Justice Roberts and Justice Gorsuch both read the law and said, hey, all I'm here to do is call, balls and strikes, that this is what the law says. I'm not here to do anything else. Law says because of sex, you fire someone because they're a man dating a man and not a woman dating a man, that's because of sex. So I would say, when you read some of these laws, some of the opinions, try and give the justices a little bit more credit, because I think they truly try, that they're not up there trying to be conservative or trying to be liberal, and you'll get decisions like this that may surprise you if you just thought that way. So sorry that's my one soapbox for the day, just something to think about. Now then, yeah, I don't know how long I've been talking, but we're finally getting to the Equality Act, I promise. So the proposed act really amends 1964 Civil Rights Act to protect LGBTQ people from discrimination in employment, housing, credit, jury service, federally funded programs, health and education, and public places of public amusement and spaces. The bill has been tried in some form or fashion a couple of different times. It previously passed the House in 2019, and as you imagine, would get stalled out in the Senate. I think the law's impact would be different in practical terms today than it was back then. So I'm really going to focus on today. What are we looking at? So first, and this is kind of the low-hanging fruit since I've talked about Title VII so much and the Supreme Court's Bostock decision, why amend it? We've got those protections. You just spent however long, Lanny, talking about the protections we got from the Supreme Court in Title VII. Well, I think that it does a couple of things when we codify it, when we put it into law written down. So first, this would do exactly that. It would write it down. It would say, that Supreme Court opinion, it is now written law. It is the law of the United States. The main benefit to this is that it means a future Supreme Court can't go back on it. You know, they can't reverse that decision if we put it down in writing. You know, they can't undo it. They can't say, well, that past court got it wrong, because we're looking at an entirely new law now, a law that says these people are entitled to protections for sexual orientation or gender identity. So that, I think, would have the main benefit of not being able to be undone in the court system. And it would be a great expression that this is something so important to the people, to our legislature, that we are going to put it down in writing, that we are going to say it is illegal to do these things. And I think that this is kind of the simplest one, because again, this is currently the law, but it's very important to do this, to have that statement, that expression. So the next sort of big provision, as I see it in the Equality Act, is as it relates to fair housing. And I don't have to do a whole lot of fair housing, just reading laws, etc., working for the municipalities. It does come up occasionally, though. We are under a dictate to have, I believe, a fair housing statement and an ordinance or a resolution saying we support these things. Most cities passed those long ago. But for those of you out there who mostly do employment law, I think you may be like me, and this may be just a slightly different foreign concept. So the basics, as they are today, the current law. So fair housing prevents discrimination in housing-related transactions, including the sale, rental, and financing of dwellings. It's pretty broad, applies to a lot of people. I think if it's very, very small, like you have one house, you may escape the application of the law, but it's very broad, applies almost to everyone. It impacts municipalities also because it has zoning impact. It says, you know, you can't pass these laws to exclude people, municipalities. Typically this comes up not as it relates to race or national origin, modernly at least, but it comes up as it relates to people with disabilities or people living in assisted living communities. You have to treat them fairly. You have to give them equal housing opportunities under the law. So explicitly as it is today, it bans discrimination on race, color, religion, sex, familial status, so married, unmarried, children, no children, national origin, and disability. So part of the logic would be for amending this, or saying, no, don't amendment, it says sex. We know what sex means. You know, the Supreme Court ruled on Title VII. This is just another title. Why do we need this? Well, the Supreme Court's always very good about only answering the question asked of them. And the Supreme Court in Bostock was asked, does sex, as it relates to Title VII, include gender identity and sexual orientation? And they said yes. And they said absolutely nothing about fair housing. So maybe it's necessary, maybe it isn't, but it'd be very clear and provide consistency to amend this. So a few more FHA notes. It applies to dwellings, houses, anyone that receives federally subsidized housing or accepts those sort of funds. And again, there's very few exceptions to this. Think about it, it could be houses, apartments, university housing, farm workers housing, sort of itinerant farmers, or nursing homes. Not dwellings as it's currently written, motels, jails, bed and breakfasts, these places that are, except for maybe jails, very temporary stays. So, back to the Equality Act. The Equality Act similarly modifies this to explicitly codify the protections for sexual orientation and gender identity. And from everything I've ever heard from anyone, this is incredibly important because there's no protections out there. We have landlords that can discriminate freely based off of these things. If they don't like you because there's two females on an application, they can do that, and there's not a lot of recourse. So I think that there's at various times different rules and different regulations depending on who the president is. They get to sort of put their thumb on the scale of the regulations. So not the laws, but the regulations put out by the departments. And the protections kind of fluctuate thusly, and this would stop that. This would say, here's the baseline, you can't do these sorts of things. If you would, rent your house out to Lanny, you're gonna rent your house out to Lanny no matter who he's dating, that sort of thing. Again, there's a lot of other provisions. It's a very thorough, the Fair Housing Act as is, so adding this amendment would add a lot more protections, and I'll just read a little bit, then renting, selling, pricing, eviction, service provisions, shelter access, homeowners insurance, mortgage lending, and other activities. It prohibits harassment, coercion, and retaliation. So it would be a massive step forward for protecting the rights of a large group of people. So another one, and every once in a while, I'm sure we're all sort of similar in this boat. We'll be scrolling through social media and we'll say, read something shocking. And we'll go, oh my gosh. I'm a skeptic. When I read these things, I go, probably not true. If it's shocking, I don't believe it. Just that's my default. I'm going to research it and find out. So as we're getting into fair credit, here's one I saw on social media. It said along the lines of, women couldn't open a bank account or get a credit card until 1975. I read that and go, well, that's patently false. My mother, born in 1958, she could open a bank account and get a credit card. And then I looked up the law, and no, that was pretty well the case, that it was incredibly difficult. A bank could discriminate based off of sex, and did, as did the credit lending companies. They go, ooh, unmarried woman, red flag, not going to do business with you. Or they'd go, oh, you're married, well, send your husband in. He can open the account. And it was a real just shocking moment. This was just a week ago. You'd think I'd have learned my lesson by now, 6 years into the practice of law. I hadn't. I read it and was aghast. So think about how recent that is, just putting your money in a safety deposit box. And think about the large groups of people who don't identify like us, who have different preference and partners, and they're in the same boat. They can be discriminated against very similarly. So I wanted to emphasize Fair Credit Opportunity Act, which is what this is. So again, that's the backdrop for it, why it was necessary to pass in 1974. And what it did was make it so that no creditor could discriminate against any applicant with respect to a credit transaction on the basis of race, color, religion, national origin, sex, or marital status, which is something you don't see a whole lot in laws. They don't usually say marital status, or age. You couldn't discriminate because someone received public assistance, or because they exercised any right. So an anti-retaliatory provision in there. So at the end of the day, this was intended in 1974 to make credit equally available to all creditworthy customers without regard to sex or marital status. This act was passed at a time when discrimination against women was rampant and very real. It was, again, very shocking to me. Not long after it was passed, Congress had to amend it again, sort of like the Pregnancy Discrimination Act in Title VII. They had to go back and amend it and prohibit it for other sort of consumer protection reasons. So I think I've pretty well covered this. I may have repeated myself, so forgive me. So we'll go back to the present now, back to the future, Marty McFly this, and we're back to the Equality Act. And it is doing those sorts of same things. It's saying that when someone goes to get a car loan, goes to get a mortgage, credit card, student loan, small business loan, you can't treat them differently because they're part of the LGBTQ community. That is not something you can any longer consider. And if I can take a step back, I think, I'm mostly up here for the sort of legislation talk, but if I can put my attorney hat back on and kind of give some good advice, what gets me with a lot of this, and something I would caution a lot of you about, in the hiring process, I know the first thing we do, and I'm looking around at the few people in the room, first thing we do when we get an application, we go look them up on social media. That's the first thing. And I always advise people, and no one has ever once taken my advice, don't do it. Don't go to the social media. I know it's tough. They could be a crazy person, and you want to know that information. The problem is, as soon as you go to their social media accounts and start looking, you get all this protected information. You start learning these things about the people. Hey, what's their religion? What church do they go to? What's their gender identity? What's their sexual orientation? Are they married? Are they pregnant? And you're just, it's just like asking it in an interview. We never ask someone those questions in an interview, but we go out there and we get all the information we can via social media. And I would say if we have to do it, make sure a professional's doing it. Make sure it's HR doing it and no one else, and I know I'm probably speaking to the HR people. Have this conversation with your bosses, whether that's corporate or government. Have that conversation and say, hey, whenever we do this, we're exposing ourselves to liability. Now then again, I hope y'all forgive me for the anecdotes, but I had a friend who I'd say sort of mid-level manager situation, and I told him this. I go, hey, this is my advice to you as a good attorney. He goes, oh, Lanny, I have a foolproof strategy around this. I go, oh, what's that? He goes, I'd lie. I'm like, no, that's not an option. He's like, yeah, I'd just lie if I was in a deposition. I'm like, no. So guys, that's the only way out is committing perjury. Don't do it. That's not a good situation. Okay, so a quick one that I didn't have just the history on as much as the others. Jury service is also included in the Equality Act, and it is sort of not codifying, but in criminal law and civil law, you can't strike members of a jury because of their race. You can't say, I don't want this jury member because of their race or because of their national origin. And this would provide those similar protections for sexual orientation and gender identity, and say, no, you can't exclude these people just because of that from the jury. And we think about this constitutionally. We all read the Bill of Rights. We know that, hey, the right to a jury of your peers has been in the United States forever. That's just part of it. And it really comes from England and comes from the Magna Carta. Hundreds and hundreds of years ago, you get a jury of your peers. And something to think about always is, am I getting a jury of my peers, or are my peers being excluded from this jury intentionally? And that's the thought process behind this, is we don't want this sort of, insidious court system. We don't want a court system that's excluding people just because of these characteristics, because it's one, not representative of the nation we live in, and two, denies someone a jury of their peers, and that's just not good. So the Equality Act takes aim at that, and that is one of the provisions. So federally funded programs. This would have been Title VI, I think, if we were thinking about the original act. So anywhere federal money goes, and it goes to a lot of places, again, transit systems, schools, health care, adoption agencies, just about anything that's doing something good is probably receiving some federal money. And this one is pretty clear on that. Again, it's if you're taking federal dollars, you're going to play by the federal playbook, which is no discrimination based off of gender identity or sexual orientation. This would pretty much subsume Title IX of the Education Amendments, because just about every school out there, certainly every public school receives federal funding, and a lot of private schools receive federal funding. So just something to keep in mind, that this would be very broad. This would apply to most aspects you can think of. And I bet it would work its way into grants, which I think everyone loves getting a grant. So the Equality Act and Public Services, I want to point out that this is a very large one, and originally, and I think as written, doesn't include sex currently, and this is Title II of the Civil Rights Act of 1964, because the thought process at the time was race discrimination. This is what's going on, the segregated water fountains, these problems, turning away minorities. So sex didn't even get included in this originally. So the Equality Act would fix that and say, no, 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 no. You can't discriminate against women. You can't discriminate against sexual orientation or gender identity as it comes to these things. And currently, it really applies to things like retail stores, transportation, healthcare providers. It's these sorts of things that people go to out in the public. So public in this aspect, not talking about the government, we're talking about places people go to out in the real world. And it would really expand some definitions. So this is one of the provisions in the law that changes not only who we're protecting, but sort of how we're protecting these things. So just some examples to think about. It would now be unlawful for contractors or mechanics or car dealerships to charge men and women different prices, which I think, if we got spreadsheets out and could look at all the numbers, might be happening. It would ensure that breastfeeding mothers have rights and remedies and aren't excluded from these public areas. That, like, oh, can you go, over, oh, can you go out back and do you have to do this here? None of that, none of that. This is part of just living, accept it. And it would say that pharmacies have to fill a woman's birth control and transgender individuals' hormone prescriptions. And finally, it would provide protection, and this is the one where, again, I'm sure we've all seen going viral or on the news. It would protect people from harassment in restaurants and other places of public accommodation. These sorts of allowing these things to happen out in the open would die down. Now then, I'm winding down on this. I'm leading up to another large amendment part from the Equality Act, and it deals with religious freedom, specifically Religious Freedom Restoration Act, RFRA. But I wanted to give, again, the backdrop for everyone. I think we all know it, but I've just got to be thorough. I've got to be thorough, forgive me. We all know the Supreme Court's case, the bakery case, the bake shop case, where two men, husbands, wanted to get a wedding cake made, and they go to a baker in Colorado. And I will, spoil the story. The baker says, no. I'd be happy to make you any other cake. I'm not going to make your wedding cake. I don't believe in it, don't think it's right. So the problem there in Colorado had its own anti-discrimination statute, and it said you can't do that. You're a place of public accommodation. People come to you. You're open to the public for them to come and buy cakes. You can't discriminate. So the baker challenged it. He sues. He says, no, that law's invalid. I have rights to turn people like this away. And Justice Kennedy, former Justice Kennedy, wrote for the majority and sided with the bakery in this case. So we're going a couple of years back. He sides with the bakery. Forgive me. We're almost at the last time I'm going to read at you, I promise. So Justice Kennedy, in siding with the bakery, said, our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. For that reason, the laws and the Constitution can, in some instances, must protect in the exercise of their civil rights, the exercise of their freedom and or terms equal to others must be given great weight and respect by courts. A lot of positive things for a negative ending. At the same time, the religious and philosophical objections to gay marriage are protected, and the views in some instances are protected form of expressions. As this court observed in Oberfeld v. Hodges, the First Amendment ensures that religious organizations and persons are given proper protection when they seek to teach the principles that are so fulfilling and central to their lives and faith. Nevertheless, while those religious and philosophical objections are protected, it is the general rule that such objections do not allow business owners and other actors in the economy and in society to deny protected persons equal access to goods and services in a neutral and generally applicable public accommodation law. So that public accommodation law part was dicta. Didn't really matter to the holding because that wasn't before the court. He wasn't making any decisions about that. He was just saying, could Colorado enforce this as it relates to the bakery's First Amendment protections? And he said, no, He gets First Amendment protections. What the court didn't do is address how the public accommodation laws, Title II of the Civil Rights Act, impacted this. Just expressly didn't address the other federal laws out there. As the Supreme Court likes to do, it likes to give the smallest ruling possible and saying, figure it out and come back to me. Punting, as we refer to it. So a very large section of the Equality Act, and I suspect, I haven't done a lot of reading of thought pieces and opinions on this. You know, I read the law, that's what I'm here for. But what I suspect is the most contentious part expressly amends the Religious Freedom Restoration Act, RFRA. And what RFRA did is say that as the government, we're going to set a higher burden on ourselves as it relates to religious freedoms, in that people can challenge our own acts, the government's acts, under RFRA, and we're going to make the standard very tough for the government to meet. So it makes it easy to challenge things religiously as they come from a government entity. So what this does, the Equality Act, as it amends RFRA, it says, no, the Equality Act controls. RFRA, that's nice, you're another act by the legislature, but what we're going to do is say that the Equality Act, higher up than RFRA. You know, your provisions are nice, but you're not going to impact what we're doing here today. So as it's been described, as this would ensure that religion cannot be weaponized as a license to discriminate, including against people for their religious beliefs, in accordance with the Religious Freedom Restoration Act. So again, I expect that to be a real bone of contention with all of this, but it's kind of, you know, tough to wrap your head around of this one act is controlling all these other good acts, and they're trying to limit it as it applies to these things, because while I mentioned the Colorado case, I know it's all over the country that, well, I can't do this because of my religion, and that may very well be true. And maybe the Constitution will protect you, but what Congress is saying is Congress isn't going to protect it. We've looked at the discrimination, and this is so severe, we have to offer these protections. So that's kind of my thoughts on the Equality Act, and let's talk about where we're going from here. So this has been passed, I think, twice now by the House and went up to the Senate. It happened in 2019 with unanimous support among Democrats and with some Republicans saying, yeah, it's time. Let's do this. In March of this year, 2021, we had our first hearing on it in the Senate. The Senate took it up and had the first hearing. Now, I reviewed all of the sort of legislation actions, and I think that was the last one so far. So it's been sitting still, but it's still there for quite some time. I think we'd expect something this contentious to need 60 votes. It would have to overcome a congressional filibuster, you know, where as long as they can stand up there and talk, they can stop any sort of legislation. There's a lot of possible political maneuvering that could change that. You know, you always hear the big thoughts of, will they get rid of the filibuster? Will they change these rules? And it's tough to tell. You know, I can't say it, but I also didn't expect the trillions and trillions of dollars in CARES Act funding and American Rescue Plan Act funding that came down from the legislature over the past 2 years. So it's tough to say. It's tough to say if this will become law. But what I would advise everyone to keep in mind moving forward is, even when this doesn't become law, think about what these people are trying to do. Think about what Congress's intent is. And as HR managers, you're going to see individuals doing this. You know, if you had a boss try and do something improperly because of sexual orientation, whether it's in employment, public accommodation, whatever, it's going to probably result in a lawsuit eventually. Maybe you get away with it once, but it'll end up there. And it's good to think, you know, zooming out, why are we making decisions? Well, we want to protect our organization. We want the best employees in the world. We want the best communities in the world. And I think that is always true and has nothing to do with these sort of characteristics. I don't care what any of the employees, you know, do on their own free time, as long as they're the greatest employees I've got. And that's what we all need to focus on, is what we're looking for is good employees. And, you know, I'm not looking for people who identify like me or agree with me. And the more you can focus on, hey, let's get work done, I think the better off you'll be in all aspects. And with that, that's all I've got. Thank you for the time today. And if you need anything, have any questions, feel free to contact me. Thanks.